So, in India, what's the real difference between just a good idea and an invention that's legally protected? Well, the answer is hiding in plain sight, inside a single rulebook. And today, we're going to crack it open and decode the exact language that turns a spark of creativity into a real, valuable asset.
We've all been there, right? That light bulb moment. An idea for a new app, some cool gadget, or just a smarter way of doing things. But what actually separates that fleeting thought from something you can own, something you can protect? Well, there's a line, and it's drawn by the law. And that's exactly the line we're going to trace today.
To find that line, we can't just guess. We have to go straight to the source, the legal bedrock for all of this stuff.
And here it is, the Patents Act of 1970. Just think, for more than half a century, this single document has been the ultimate playbook for innovation in India. Every single rule, every definition we're about to get into comes directly from these pages.
Okay, so this entire act, it really spins around one central concept, the patent. So it makes sense to start right there. What does the law itself actually say a patent is?
You might expect some complicated definition, but it's surprisingly simple. The Act says a patent is a patent for any invention granted under this Act. Now, I know what you're thinking. That sounds like it's just going in a circle. And you're right, it is. But that's a huge clue. It tells us that to get what a patent is, we first have to figure out what the law means by an invention.
So, a patent is for an invention. That brings us to the million-dollar question. What is an invention, legally speaking? This one definition, it's the real foundation for the entire patent system in India.
And the Act doesn't just leave us guessing. It actually lays out a very specific three-part formula that any idea has to follow to even be considered a legal invention.
And here is that magic formula. For an idea to get legal recognition, it can't just be clever. It has to check all three of these boxes. It's got to be new, it has to involve something the law calls an inventive step, and you have to be able to actually use it in a practical, industrial way.
Let's think of these as three gateways, right? Any new idea has to pass through all three to become a protected invention. So let's take a closer look at that first gate.
The first test is all about novelty. In simple terms, your invention has to be brand new. And I mean new to the world. It can't have been published or talked about publicly anywhere in any way. If it's already out there, part of what's called the state of the art, which is just all the knowledge that's already public, then it fails the test. It has to be genuinely new.
Okay, second, and this one can be tricky, is the inventive step. This is basically the test for non-obviousness. Your idea has to be a technical advance or have economic significance in a way that isn't obvious to an expert in that field. So if someone who knows their stuff would look at it and say, yeah, of course, that's the next logical step, then it's probably not an invention. It has to be a real leap in thinking, not just a predictable little hop.
And the third and final test is industrial application. This is the reality check. An invention can't just be a cool theory you have or an abstract idea. It has to be something that can actually be made or used in an industry. It needs a tangible, real-world purpose.
So, let's say an idea makes it through all three tests. Boom, it's officially an invention. Now the law gets very specific about the people involved, and you've really got to understand these roles to know who owns what.
The law makes a very clear distinction between two key people. First, you've got the patentee. This is the owner on paper, the name on the official records, which could easily be a company. But then there's the true and first inventor. That's the actual creator, the person with the idea. And the Act is very clear on this. You can't just be the first one to bring an idea into India and claim to be the inventor. This is all about making sure the original creator gets the credit they deserve.
Look, I know we've waded through some pretty dense legal language, but getting these definitions right is everything. They're the foundation of the entire system. They decide who gets rewarded for their creativity and how we legally protect and, encourage the engine of innovation to keep running.
So let's just quickly recap the big points. 1. A patent is the official shield for an invention. 2. An idea only gets to be called an invention if it passes those three tests. It's new, it's not obvious, and it's useful. And 3, these rules are what make the whole system work, rewarding big leaps in innovation, not just the small stuff.
And all of this leaves us with one massive question. This law was written in 1970. That's long before AI, biotechnology, and the insanely complex software that runs our world today. So, do these 50-year-old ideas of what's new and inventive still fit the cutting-edge tech of our time? Well, that's the massive challenge that inventors, lawyers, and courts are all grappling with right now.